Welcome to the second day of our conference. We start with Professor Sergio Dellavalle from the University of Turin. His main field of research are philosophy of law, political philosophy, state and international theory. He is the co-director of the research project Paradigms of Public Order with Professor Armin von Bogdandi, and a member of the Cluster of Excellence Normative Orders at the Goethe University Frankfurt. And next year we will proudly host him as a visiting fellow at the Globaltrust project here. He will talk about why should state have obligations towards non-national citizens, a philosophical attempt. And the comment will be by Alon Harael, whom you all know from Hebrew University of Jerusalem, a visiting professor at Tel Aviv University this year. And he recently published a book with OUP entitled Why Law Matters. Researches on many issues, including moral and political philosophy, philosophy of law, criminal law, law and economics, and other areas. Sergio, please.
Thank you very much. First of all, I want to thank the organizers for inviting me and giving me the opportunity to present some consideration and discuss them with you, some considerations on the relations between sovereignty, legitimacy, and solidarity. Let's start. Sovereigns are generally thought to have obligation, mainly if not exclusively, toward themselves. Indeed, the assumption that actors, in this case state, do not accept any moral, political, or juridical authority above and beyond themselves may imply that they reject any obligation to solidarity toward their fellow humans which could be drawn from such an authority. However, we have at least one alternative definition, according to which sovereignty consists in the legitimate exercise of public power. If we adopt this second definition, sovereignty would not be in contradiction with responsibility for others and with solidarity with no citizens any longer. The transition from this traditional concept of sovereignty to its alternative understanding corresponds, furthermore, to the passage from its exclusive, hierarchical, and authority-based conception to a rather inclusive, network-oriented, and dialogical view. Given these premises, my contribution will concentrate on two essential elements for the definition of sovereignty. First, the question regarding its sources, and second, the conceptions of rationality that are applied when sovereign authority is put into effect. Let us begin, therefore, with the first element of sovereignty, namely with the different fundaments from which legitimate sovereign authority can be drawn. Essentially, they are of two kinds, ascending and descending, and depend primarily on how the legitimation of public power is conceived of. Following a first and more ancient understanding, the legitimation of public power has a descending character, which means that it derives from an authority situated above the individual, so that the holders of public power are vested with it without resorting to any investiture coming up from the governed. The first and most prominent example of the idea that sovereignty is derived from the assumption of a kind of natural superiority of the power holders is given by Jean Bodin. However, Bodin's idea may find its continuation or revival, if you want, in the technocratic postulation of an allegedly superior knowledge and expertise with which the holders of public authority are thought to be vested. Surely, technocratic paternalism, an excellent example of which has been displayed by the measures taken by the European Union in order to meet quite with little success the debt crisis in Europe, is far from absolute. So that technocratic sovereignty, provided that we can apply the concept of sovereignty in these cases, is of a quite different kind than in Bodin's conception. Nevertheless, the idea that an authority should derive the legitimacy to take decisions from a supposed natural superiority or supremacy, be this rooted in tradition or your knowledge, shows the continuity and liveliness of the dissenting conception of public order. According to a second definition to the contrary, legitimate sovereignty can only be established in an ascending way, namely explicitly, or at least implicitly, by a free act of those individuals who are willing to create a political community and the institutions that shall govern them. The ascending idea of sovereignty arose as a consequence of the transition from the holistic to the individualistic paradigm of social order and was introduced by Thomas Hobbes in the middle of the 17th century. Hobbes overturned for the first time in history the traditional hierarchy between individual and community, collocating the individuals as the holders of fundamental rights and the starting point of any legitimation of authority at the center of political life. Therefore, in this understanding, sovereignty is legitimate only if it aims at safeguarding the fundamental rights and is grounded on a freely and explicitly expressed people's consent, in the strand of political thought initiated by Hobbes, in particular by means of a contract or of a pactum unionis. The difference between the descending and the ascending understanding of sovereignty is very important in order to qualify not just the sources of public power, but even more its degree of legitimacy. Indeed, from the perspective of legitimacy, the distinction between the descending and the ascending conceptions is clear-cut, and the criterion for a normative evaluation of the two conceptions is unambiguous. In fact, within a post-metaphysical, ideological and political context, two assumptions have to be regarded as self-evident. First, no supposedly higher truth of natural or divine origin, and we could add of scientific or economic, and one word of technocratic origin as well, can be legitimately imposed on the whole political community. And second, as a consequence of the first assumption, sovereign authority is legitimate and has the justified competence of issuing decisions that bind the whole society only if it is created from the bottom up. Therefore, merely the ascending conception of sovereignty can found its legitimacy. The question is, however, much more complicated instead as regards the openness of sovereign powers to solidarity toward aliens. In fact, both understandings of sovereignty are compatible with either option, with egoism and with unselfishness. As a result, no direct relationship can be ascertained between the sources of sovereignty, ascending or descending, and the possible obligation to solidarity towards others. Solidarity can come along with a bottom-up legitimation or with one from above, and the same can do selfishness as well. Thus, if we consider sovereignty from the perspective of its origin, it seems that we cannot collect any evidence that may help us to understand whether sovereignty also implies duty towards non-citizens and why, if this is true, solidarity should be owed to them. If we want to try to find out the possible reasons for sovereignty to be open to arguments and interests of the others, we have to change the focus of analysis and concentrate on the forms of rationality implemented by sovereign acts. When a sovereign actor implements an action, it necessarily makes use of its practical reason. That means it applies a certain understanding of how it should reasonably act in the world. In other words, it applies justifiable criteria for its action, whereas these criteria can take different forms, each of them characterizing a specific rationality of action. In the following, I will examine the most relevant kinds of rationality which are applied when sovereignty is put into effect. I propose to take into account 6 conceptions of rationality. The first one is what we can call a particularistic understanding of reason. We can find its best expression in the idea of sovereignty realized in the tradition of national constitutionalism. According to this approach, only the sovereign national state, based on the primacy of the national constitution, can guarantee the rule of law and a high standard of legitimacy, both of which would be lost in the context of a cosmopolitan turn of constitutionalism. According to the particularistic understanding of reason, rationality is never situated beyond the limits of a particular society, since it is essentially embedded in the language, in the history, and in the traditions of a specific group of individuals or of a people. We have thus many rationalities, each of them specific to an individual society, but we do not have any universalistic reason that may lead the members of the single polity beyond the borders of their original belonging, transcending their selfishness and connecting them to every human being. It is almost superfluous to point out that this conception of rationality is completely inadequate to support solidarity towards non-citizens and represents rather one of the most frequent arguments brought by the counterpart into the debate. A second concept of rationality has been developed by systems theory. Here, rationality is reduced to its functional dimension. It does this by eschewing any reference to an overarching rationality that would encompass all forms of social interaction. No universal reason, subjective or intersubjective, is here envisaged. Functional rationality is transnational in its essence because it does not stop at the borders of nation states. Yet transnationality does not mean solidarity, nor it implies it. Indeed, solidarity with the powerless may go far beyond the search for the best way for accomplishing functions, and in some cases it may even run against this principle. Therefore, why should we owe solidarity, nevertheless, to the excluded and powerless and neglected? Systemic rationality does not rule out this explicitly, this possibility or this obligation, yet it does not give us any argument in favor of it either. A third conception conceives of rationality exclusively in its strategic dimension. In this sense, reason is the instrument that enables us to maximize our payoffs. Some authors have argued, particularly Goldsmith and Posner, that this kind of perspective justifies an egoistic behavior of the states. However, if the strategic rationality of self-interest regarded from the perspective of the immediate payoffs may be seen as a strong argument against solidarity, from a broader perspective, self-interest can also be considered as a claim in favor of it. Even if egoism is thought to bring immediate payoffs, a more open attitude toward the others may turn out to be of greater advantage in the long run. This approach maintains, however, that a rational action must always aim at maximizing the gains of the individual actor. On these terms, the question remains unanswered: how we could meet the attitude of the so-called free riders. Free riders comply with the rules of interaction, in our case with the rules which guarantee an essential level of recognition for the arguments of the others, just as long as they see in this behavior a gain for themselves. Therefore, they are always prone to breaking the rules as soon as they see a greater advantage to them from such a breach. Under the premises of the definition of rationality as the maximization of individual gain, there can be no doubt that the behavior of the free rider appears to be here the most rational choice. Yet it is difficult to imagine how social interaction can be stabilized under these conditions. This can be said not just with reference to the preconditions for a functioning democracy, but also as regards the dispositional framework of international relations aiming to concretize peace, mutual recognition, the guarantee of fundamental rights and justice. Therefore, even if we overcome the short-sighted point of view that privileges immediate advantages of the individual actors in order to adopt a position that put more attention on long-term benefits, strategic reason cannot really explain why the strongest and the wealthiest should owe solidarity to the weakest and the poorest, namely to those from whose life conditions enhancement they will not draw any profit, either immediately or in a foreseeable future. A fourth approach considers rationality in a holistic sense. According to this, solidarity is owed to every human being for the simple fact that he or she is thought to be a member of the universal humanity, considered as sharing fundamental values and interests. The whole of universal humanity is regarded as a fact, grounded of the essential ontological features of our species, in particular on the assumption of a natural sociability of humans. Against this background, international law has to be interpreted as the legal expression of the activity of the international community. As the common law of mankind, it arises as the formalization of shared values as well as of the rules that guarantee the protection of common interests. Yet the case for solidarity depends here on the epistemological status of the proposition, asserting that a universal human community exists which shares fundamental values and interests. Indeed, if we consider this assertion a little bit more in depth, we cannot but ascertain that it does not satisfy the most fundamental epistemological consistency condition. In fact, empirical evidence of such a universal human community are rather controversial. The realistic assumption of a permanent struggle for survival between human communities shows indeed not less evidence. As a result, if the truth content of these claims is proved to be uncertain, there would be no reason why we should regard our fellow humans as deserving our solidarity. The content of the assertion, as any realistic analysis of the relations between states and individuals could easily demonstrate, is far from self-evident. Humans can be no less prone to selfishness than to altruism. Thus, the pre-reflexive assumption of an ontological sociable humanity is just a circular argument when it comes to prove the duty to solidarity. A fifth concept of rationality, or I should rather say the first and only negative concept of rationality in this analysis, resorts to the postmodern critique of modern rationalism. Translated into the language of legal theory, and in particular of the theory of international law, postmodern criticism maintains that international law is not the legal expression of an ontological, moral, or epistemological universal truth. Swinging necessarily between apology and utopia, its norms and practices miss objectivity and thus universal validity. The critique against the universalistic claim of the international law discourse does not lead, nevertheless, to sheer nihilism. Indeed, the international law theorists, influenced by postmodern thinking, accept the ideas that some experiences may occur which are not characterized by mere contingency, but take up, on the contrary, the kind of universal scope. From the postmodern standpoint, however, this unassuming universality is not based on abstract ontological, moral, or epistemological principle, but is derived from the concrete experience of vulnerability among all involved individuals. Artistic expression is probably the best suitable way to give a voice of universal reach to a humanity made of concrete human beings. But also the law, due to its formalism, can play a role to accomplish this task. Following this interpretation, there is a non-ontological, non-moral, and non-epistemological universalism that originates specifically from a deconstructed idea of rationality. Reason, according to this understanding, does not help us to recognize objective and universal values, nor it is necessarily the means for the achievement of egoistic payoffs. Rather, every concrete individual applies practical reason to achieve his or her priorities, some of them pursuing selfish interests and some others concretizing altruistic attitudes. As a result, solidarity is not an obligation but a choice that some actors, individual or states, make following a sentiment of empathy toward the fellow sufferers. Yet doubts arise on whether this postmodern version of the universalism of the law can really justify the claim for solidarity as an obligation. Indeed, if no epistemological argument thought to substantiate the universality of international law is convincing, then also the universal dimension of legal formalism is not an assertion that every human being has to share, but the personal commitment based on empathy, regardless of how important empathy may be as a motivation of personal action, cannot offer a solid basis for a legal system necessarily related to the essential quality of the law as an ought. Empathy is fundamental but personal. The law, on the contrary, specifies the compelling rules which guarantee order in the international interactions of an entire society. In the case of international law, even of the world society. From the perspective of a deconstructed rationality, thus, solidarity is just an option, not a moral duty that, because of its universality, can and should be transferred into legal norms. Solidarity may resort to empathy as regards the mindset of individuals, but it must rest on a psychological neutral commandment of reason if it has to be seen as a general moral and legal duty, and if it should be adequately substantiated by rules and practices. A sixth and last conception of rationality, the communicative rationality, conceives of society as made not only by functional systems but also by a live world of intersubjective relations, which is characterized by different forms of interaction. According to these premises, each level of public law corresponds to the legal regulation of a specific kind of social interaction. First, domestic public law regulates the interactions between citizens of each single political community as well as between these citizens and the institutions of the same polity. Second, international public law addresses the relations between citizens of different states insofar as they are primarily regarded as citizens of the state. Therefore, the regulation between individuals which are here the object of regulation are processed through the form of relations between states. And lastly, the third level of public law is made by the cosmopolitan law as the public law that regulates the direct interactions between individuals from different states, as well as between individuals and the states of which they are not citizens. The necessity of this third level is given by the fact that individuals meet and interact with each other outside the border of the single states, regardless of their belonging to a specific political community. Cosmopolitan law consists, therefore, precisely in those principles and rules that guarantee a peaceful and cooperative interaction between humans within this most general context of interaction. In these rules is the fundamental recognition embedded that we owe to every human being as the consequence of the universal capacity to communicate. In this sense, solidarity is an obligation, and its essential principles and norms have necessarily to be laid down as a fundamental part of the most universal corpus of public law. And now, some conclusions. 5 minutes. In order to meet the challenges of a post-national constellation, the concept of sovereignty has to be reshaped. In particular, sovereignty does not have to be understood any longer as the condition in which an authority does not recognize any higher power above itself, but as the situation in which public power is legitimately exercised. In other words, in the contemporary context, only legitimate power should be seen as a sovereign power. The first implication of this tenet refers to the sources of sovereignty. Given the centrality of legitimacy, on the one hand, and the assumption that from a post-metaphysical standpoint only the democratic process fulfills the criteria for at least the possibility of a reflexive legitimation of authority, the consequence is that the only acceptable source for sovereignty is the one that comes bottom-up. That means ascending from the free will of the governed. Yet if the legitimacy of sovereignty is limited just to this tenet, nothing would be achieved as regards the solidarity towards others, or the openness to their needs and arguments. A public power may be legitimate from below and nevertheless selfish. Indeed, the idea of a solidaristic sovereignty needs more than just a legitimacy bottom-up. It requires also a specific concept of rationality that should be itself better adapted to the conditions of an increasingly interconnected world. Different conceptions of rationality have been scrutinized. As a result, it can be maintained that sovereign actors have an obligation to solidarity only if they implement in their actions a practical use of reason, that means rationality, that is non-particularistic, that means universalistic, non-functional and non-strategic, that means consent-oriented, non-holistic, that means avoiding any metaphysical or ontological presupposition, and non-deconstructed, that means actually deontological. In other words, universalism, consent orientation, as well as a post-metaphysical and deontological attitude are the inescapable conditions under which the use of reason by a sovereign actor can lead to the determination of solidarity as an obligation and as a compelling legal norm. Communicative rationality meets these requisites, paving the way, therefore, for an understanding of sovereignty which is at the same time legitimated by the individuals who are subjected to the sovereign power as well as open to the others. Indeed, from the communicative perspective, since every individual is always involved in different forms of interaction, as a citizen with the other citizens and of his or her political community, and as human being with all other fellow humans inside as well as outside the community, the legitimacy of a sovereign public power is guaranteed only if it comes from the governed, not only in their role as citizens of the polity, but also in their no less important position as citizens of the cosmopolis, or simply as human beings. If we take this point of view, the legitimacy of sovereignty has a two-level structure, a domestic and a cosmopolitan. Thus, a sovereign power will be legitimate only if it takes into account, along with rights and interests of the citizens of its own polity, also the justified claims of the international community. Thank you very much.